Mr. Speaker, I rise today in strong support of the resolution, and I yield myself such time as I may consume.
Gentleman's recognized.
Mr. Speaker, during the past 8 years, a number of newly issued regulations and the cost of those regulations have surged. By the prior administration's own estimates, federal regulations promulgated over the last 10 years alone have imposed a cost of more than $100 billion annually on the American taxpayers. House Joint Resolution 37, which we are considering today under the Congressional Review Act procedures, represents an important step towards rolling back this tsunami of rules. Once a CRA resolution of disapproval for a rule is enacted, agencies cannot reissue the rule or any substantial similar rules in the future. House Joint Resolution 37 revokes the Fair Pay and Safe Workplace Rule, otherwise known as the blacklisting rule. I want to thank Chairwoman Fox for her leadership on this resolution of disapproval. I also want to recognize my fellow original co-sponsors, Mr. Chaffetz and Mr. Mitchell, for their leadership on this issue as well. And I want to highlight the impact of this rule on the federal acquisition system as well as contractors. The rule requires federal contractors to report violations and alleged violations of 14 federal labor laws and undefined equivalent state labor laws for a previous 3 years. Contractors must collect and report this information every time they submit a proposal for a contract, and then every 6 months during the contract performance. Then federal contract officers consult with their agency's newly created Agency Labor Compliance Advisor before determining if a contractor is eligible for a contract award. There are a number of reasons this rule should be revoked. The federal acquisition system is already very complex, inefficient system. This contractor blacklisting rule is exactly the type of requirement an already complex federal acquisition system does not need. The rule adds another contractor clause to an increasingly long list of clauses in every federal contract. It slows down the process that already has trouble delivering goods and services in a timely manner. It increases the burden on federal contract officers who have to review and assess the significant volume of information and take on the role of labor law experts. The rule imposes significant cost on contractors, which means the government, which ultimately means the taxpayers. The rule itself is estimated to cost contractors and subcontractors of more than $458 million in the first year and $413 million in the second year of its implementation. Some experts believe the government underestimated these costs. The cost to establish a new information collection, reporting, and assessment system to comply with the rule would be prohibitively expensive for most contractors, especially the small contractors. And Mr. Speaker, this is where the rubber meets the road, is these small contractors. In fiscal year 2016, the federal government spent more than $470 billion contracting goods and services. We need to be looking for ways to reduce, not increase, the spending in this area. The rule discourages competition and reduces access to innovation. The last thing we need to do in the acquisition system is discourage this competition and innovation, particularly for first-time participants who want to join the federal marketplace. There are already so many barriers to entry, particularly for these small businesses. So think about the small business at home. They want to compete for these federal contractors. They may be a very small organization. There's still, even after we pass this resolution of disapproval, there's still rules, there's still laws, there's still a lot of burdens that they have to deal with. But I want to cite some Bloomberg data about the number of first-time federal vendors. We have fallen to a 10-year low, down 24% in 2007, and only 13% in 2016. What that means is the big are probably getting bigger, but the small guy, the mom, the pop, the woman who's starting a new business and wants to compete for these federal contracts, she doesn't have a fighting chance. And for the federal government to put more burdens on there, especially things that haven't been substantiated, it's just not fair, it's just not right. The rule duplicates existing labor enforcement mechanisms to hold contractors accountable, and therefore, I believe, is not necessary. Revoking this rule will not leave federal contractors free to violate labor laws. To the contrary, the Department of Labor has significant oversight and investigation resources to enforce the federal labor law. Further, if there's a bad apple contractor not complying with the law, contract officers already have the authority to refer contractors for suspension and disbarment. This rule raises due process and First Amendment concerns. One of the most disturbing parts of the rule is that contractors would be required to report alleged violations, not confirmed, just the alleged violations of the 14 federal labor laws and the undefined equivalent of state labor laws. It deprives contractors of their legal rights to challenge such allegations. The reporting requirement covers non-final administrative merits determinations without regard to the severity of the alleged violation. Contractors would have to disclose National Labor Relations Board's complaints, OSHA citations, EEOC non-final letters of determination, even though these cases have not been adjudicated and the record is incomplete. Contractors challenged this rule in federal court, and the judge, in granting a preliminary injunction for the rule, found this reporting requirement could also impact contractors' First Amendment rights. The judge said that the rule could result in compelled speech by requiring contractors to report allegations that would cause a reputational harm, particularly if after adjudication the alleged allegation is found to be without merit. This rule increases costs, complexity, reduces competition in the federal acquisition system. We're having trouble getting new entrants in to compete as contractors, and therefore I urge the support of the passage of House Joint Resolution 37, and with that, I reserve the balance of our